Hi, so my name is Mary Vargas, and I'm an attorney with the law firm Stein Vargas, which is based in Washington, D.C. and Maryland, but we litigate throughout the United States. And I think this is the first time ever where I've gotten up to speak where I'm not the demon. This is awesome. I'm the good guy today, so I want to enjoy this. Well, before we go to that, let me tell you why I started doing this work. I was a disability rights attorney. I have been my entire career. I graduated from law school in 1998, and I began working on a fellowship at the National Association of the Deaf Law Center, representing people who were deaf and hard of hearing in disability discrimination cases. And I loved that work. And then I had children, and I left that job, but I was still a disability rights lawyer at heart. And when my youngest son was diagnosed with food allergies, I didn't make any connection between my professional life and my personal life. It wasn't until when he was 4 or 5 that he tried to enroll at a really awesome nature camp that his older brothers had gone to. And the Friday before the camp started, the camp director told me that I would have to wait in the parking lot throughout the entirety of camp with my son's EpiPens. He was totally welcome to come. And they were a wonderful program, and they were well-meaning, and they were not trying to harm my child or myself. But obviously, the point of sending my child to camp, from my perspective, was not for me to be sitting there hovering with an EpiPen in the parking lot. And so in that moment, I realized my two worlds actually kind of connected, and my kid was really the same passion that I had in my professional life, and that they were the same thing. There really weren't a lot of cases out there saying that. It was just more like this gut feeling, like, look how cute he is. He should be included. He could be here. So I started doing the work with food allergies, and you probably can guess how this ended. My son was diagnosed with celiac disease 2 years ago. And so, well, now celiac disease, those are my people too. And there's a lot of commonality between food allergies and celiac when you try and figure out what the legal rights are. So let's talk about those legal rights. And this is often where people want to throw tomatoes at me, because often when I talk to my people, parents of kids with food allergies or kids with celiac, there's a real resistance to saying that their child has a disability. And it's hard for me to understand that resistance because of where I came from. So let me share that with you a little bit. So when I think of a person with a disability, my picture may not match yours. When I think of a person with a disability, I think of the woman who is second from the left in the first picture. And she is a deaf-blind marathon runner. And she wanted to do the Ironman race and was told that she couldn't do it because she was deaf-blind. And in order to do the Ironman as a deaf-blind person, you need to have a wrist tether to somebody with you so you don't get lost. So you go into the right place and do the right thing safely. And we were able to convince Ironman that she should be allowed to do that, and she did it successfully. And so when I think of someone with a disability, I'm not thinking of maybe the same limitations that some people are thinking of. I'm thinking of her. And then in the picture in the middle, the fellow on the right, his name is Zach Featherstone, and he's one of my favorite people in the world. Zach is now a pediatric resident in Las Vegas. And he also happens to be deaf. And when he was admitted to medical school, he requested sign language interpreters so he could learn all the content of the classes. And his admission was retracted. And he ended up, we filed for a preliminary injunction, a court order. He was able to start medical school with a court order. And he's now completed medical school. He is exactly what I would want as a pediatrician for my child. He is an individual with a disability. And then the last guy on the right, we're going to call him JD. Those are his initials. Some of you may have heard about JD. And let me ask, there are more kids here today than I expected, which is awesome. How many of the kids in the room, if you feel comfortable, how many of the kids in the room have celiac disease? Okay, so you guys, JD was 11, and he has celiac disease or non-celiac gluten sensitivity. We're not entirely sure which, but we know he can't eat gluten or he gets really sick. JD is kind of a hero because, we'll talk a little more about it later, he's a person with a disability. That's not just my opinion. The court said so. That doesn't mean that there's lots of things that he's bad at. That doesn't mean that he's weak. That doesn't mean that he can't do stuff, except maybe eat gluten. It means that he's been able to change the world as an 11-year-old for a lot of people. And so he's also who I now think of as a person with a disability. So what is the legal definition? Because that's really what it comes down to. The Americans with Disabilities Act and Section 504 are two federal laws that provide legal rights to accommodations and to inclusion for individuals with disabilities. If you don't have a disability, guess what? You don't have any rights. So you have to fit this definition in order to be considered a person with a disability and have a right to inclusion and have a right to tweaks and little changes in how things are done in order to keep you safe and included. This is the basic legal definition under both federal laws. Do you have a physical or mental impairment that substantially impairs one or more of your major life activities? Or does your impairment substantially impact your major bodily functions? And I think anybody who's lived with celiac disease or non-celiac gluten sensitivity would say, at a kind of gut level, no pun intended, yeah, obviously, we fit the definition of a person with a disability. So it might require you to change a little bit the concept you have and the image you have in your mind, because this is what the law says is a person with a disability. And so if we have to get really specific about it, which we always do when we go to court, what kind of major life activities might be impacted? I bet everyone in this room could name things beyond eating, sleeping, thinking, learning. And the question is not, what's the impact on a day when you've done everything right, when there have been no mistakes? The question is, if you have celiac disease and you ingest gluten, does it impact your sleeping? Does it impact your ability to learn? Does it impact your digestive system, your nervous system, your skin? And if it has a substantial impact, then you qualify as a person with a disability. Once you have rights, what does it mean? It means you have a right to be included. It means that you can ask for accommodations, that things may be done differently, that the cooked pasta may be replaced with gluten-free cooked pasta. Those are examples of accommodation. It's not just in a school environment. It's in employment. It's in access to public services. It's now into restaurants. We'll talk about JD in a minute. And it also means that you can't be retaliated against because you asserted your rights. And here's a really important thing to know, and it's one of my favorite parts of this law. I'm a little geeky, obviously. My favorite thing about the Americans with Disabilities Act is it doesn't just protect the person with a disability. Because for those of you who have children with celiac disease, you are often the one, when they're young, who's on the front lines. You are the one who's making the request. You are the one who needs daycare because you have to go to work. And guess what? If you experience discrimination because your child has a disability, because your spouse has a disability, you are also protected by these federal laws, even if you don't have a disability yourself. We talked a little bit about what does discrimination look like. These are just some real-life examples of this sign relates to food allergies. Please wait outside. It's hanging today on an ice cream parlor in Cape Cod. Question what a kid with food allergies feels like when they see that on summer vacation, and what message that sends them about their role in the world, and how much they matter. The picture in the middle is from a elementary school it's just outside of Pittsburgh. And if you can see that little desk all alone back by the wall, that was the allergy-safe lunch seat. And that's where a kindergartner named TF, that's where he had to eat his lunch, at this little desk alone. one of the things we know as parents is that it isn't so much the classroom learning that's important to our kids and their development. What matters, again, is the messages they get about their role in the world, whether they're valued as part of the community, their opportunity to build social relationships with other children. This is where it matters. It's in the lunchroom. And incidentally, the court found that that was not discrimination. I obviously disagree with that decision, but we're early on in this journey in terms of convincing courts to include folks with food allergies and celiac. And then the picture on the far right is from an indoor play space for children called We Play Loud in California, and they have this sign which says you can't bring in outside food, and guess what, if you do, you can never come back again. And it's the kind of place where you pay to go all day, and there's food in there to keep you there all day. And children with dietary restrictions were being told to go outside and eat on the sidewalk. Now, they were being allowed to come back in, but again, is that the kind of world we want our kids to live in? How you answer that question is going to dictate whether you think that I should, join you with the tomatoes and be tomato bombed because I sue people for doing this stuff, or whether you think maybe it's worth trying to change the way things are done. Which brings us to JD. So JD is from Maryland. He attended a private school in Maryland. He is a huge history buff. I mean, like, really a history buff. When I first met JD, within the first easily 2 minutes, I had heard which of his relatives had fought in which wars. He really cares a lot about history. He learns a lot about history on his own. And he had always wanted to go to Colonial Williamsburg in a way that maybe not all kids do. I mean, lots of kids get excited about field trips, but for JD, this was like a huge deal. And he'd never been because this was his school's 5th grade trip. And so his parents said, let's not go to Colonial Williamsburg, let's save it so it's really special for 5th grade. Starting in 1st grade, his family began raising money so that JD could go on the trip, volunteering at school activities and fundraisers. They raised the money so that he could go with his classmates. And in May 2017, he boarded a bus with his dad as a chaperone, and they went to Colonial Williamsburg for a 2-day visit. So Colonial Williamsburg had been paid full price for JD to be on this trip. But JD gets really, really sick when he ingests even small amounts of gluten. And over the course of his childhood, his ability to eat out has become more and more restricted because he's gotten sick repeatedly at restaurants. So he really only goes to restaurants like former one-dish cuisine, places where there's dedicated equipment and there are unlikely to be mistakes. He's had mistakes at some of the places that are most well-respected in this area. So at Disney, he was accidentally given a gluten-containing pizza that was on the correct colored plate that was wrapped and marked as gluten-free, but it wasn't. Mistakes happen, right? Did they sue when that mistake happened? No, they didn't. It was a mistake, and they learned from it. They learned that when you're traveling, maybe it would be really good to manage risk and try to avoid getting sick. So they limited what restaurants he went to, and when he goes on field trips, he always brings his lunchbox with his safe food from home, and that's what he did to Colonial Williamsburg. So it was raining. It was about 54 degrees. It was kind of cold. The kids were all wet because they'd been outside all day. When they arrived at Shields Tavern, which is a restaurant owned by Colonial Williamsburg, JD and his father had both paid $30 a person to be in that facility. Now, it's not just a McDonald's, right? This is a colonial environment. Colonial Williamsburg invites people to come and experience and live the past, to feel what it was like to be in a restaurant, a tavern at the turn of the century, to understand the architecture, the clothing, the music, the social experience. It was not really so much about the food. And so when he brought in his own safe food, having been paid full price, he was just happy to be in the room until the restaurant said that he couldn't eat his safe food. And there was discussion back and forth between JD's father, who is a Navy officer, so he's not a wild guy. He's a rule follower and a lovely man. And he tried to advocate for his son to just be able to sit and eat his sandwich with his classmates. They were the only ones in the restaurant. It was a group of like 60 or 63 people. There was nobody else. And ultimately, the restaurant said he couldn't stay and he couldn't eat his food. And he was escorted out back in front of his entire 5th grade and their parents. And he was sat down at a table in the back, in the dark, crying. I don't think that's okay. I think that's discrimination. JD, he's not going to get that trip back. Hopefully we get him a chance to go experience Williamsburg without discrimination. But that particular trip, that trip's over. But he has a little sister, and his little sister has celiac disease, and she goes to the same school. So JD decided that he didn't want the same thing to happen to her. And we represent JD. We filed a lawsuit in federal court in Virginia, arguing that Colonial Williamsburg discriminated against him when they excluded him and didn't allow him to be in the room. So the judge in Virginia did not agree with us. We lost in Virginia, and the judge said, this was the good news, yes, clearly this kid could have a disability because look at all this evidence of how sick he gets. He is a doctor, pediatric gastroenterologist at Johns Hopkins. So he's not self-diagnosed. He's not just experimenting. He's got a history of like losing consciousness, and passing out, and hitting his head and seizing. Like there's a trail of bad stuff. And can we require this kid to risk this on a school field trip? The court said you could, and we lost. I had to sit down with JD in a park and tell him this and talk about his options. And JD said to me, and he said this publicly, so I'm not disclosing anything that's protected, that he's read the history of civil rights in the United States, and people had to lose first before they won. I'm gonna cry. Like, what kind of great client is that, right? And he wanted to appeal anyway, even knowing he might lose, because his sister was coming up and because there were other kids who'd looked to him to kind of take this on. So we appealed to the United States Court of Appeals for the 4th Circuit, and in June we won. And it was a really awesome day. And if you're interested in this case, I promise you it's not boring. Go to the website for the U.S. Court of Appeals for the 4th Circuit, and the oral argument that we did in January 2019 is recorded there. They're organized by date, and you can click on it and listen to the oral argument. My children, who never like to listen to my arguments, they got really into this one because it was a hot judge. I don't mean that in a bad way. That sounded wrong. Wow. So this was like an 80-something-year-old federal judge, to clarify. And his father was on the board of directors of Colonial Williamsburg. So he had some opinions. And I didn't get to talk a whole lot because he was sharing his opinions. And he was really angry. And we have a new tagline in our house. One of the things he said during the argument to Colonial Williamsburg's lawyers is, I know what's happening to you. You're being hammered for being a good citizen. And we left Richmond feeling really bad about where things were. But then there were 3 judges altogether. He was just one. And we won in a decision that says that, yes, there was clearly evidence to establish that this child, whether he had celiac or whether he had non-celiac gluten sensitivity, that he had a disability and he was entitled to protection of federal law. More importantly, the court also said it may be necessary for restaurants to allow people with disabilities to bring in safe food from outside in order to be included. That's like watershed moment right there. And for those of you who live this life, again, you know that there are lots of people who don't believe you. There are lots of people who think you're making it up or exaggerating or love the drama. There are at least 2 federal judges who are with you, and you can read the decision. It's available online. And now we go back to trial, and we see what a jury says in Norfolk, Virginia, probably in the next 6 to 8 months. So where are we? We've been spending the last few years building the foundation, and the work with representing people with food allergies and celiac disease and non-celiac gluten sensitivity, it's hand in hand, it all goes together. And when we were filing the appeal in JD's case, the food allergy community stood with us, and they filed briefs supporting us. And by the way, when we lost in the district court, the judge assessed costs against our 11-year-old client. So he obviously didn't have several $1,000s to pay the insurance company's costs. So we went public, and it was the food allergy and celiac community who crowdfunded to help pay so that he could continue this fight. So one of the amazing things about this community is in the moments when we have each other's backs, and recognizing you may not agree with every case, you also may not know the facts about every case, but behind every case there is somebody who experienced something really hard and who has the courage to stand up and ask for more. And so I really appreciate the support that the community gave to JD. I know he really appreciated it as well. But we're at this initial place. We're just establishing the rights. For a long time, the Americans with Disabilities Act didn't support our claims. In 2009, the law was changed. The definition of disability was changed, and that change allowed our cases to start being successful. So we're still just, the law moves slowly. We're still building that foundation of rights, and we're looking at what matters in our lives. And I know we're probably running out of time, but this is why I do the work, right? So that was on a Friday that we got the decision that we won in Colonial Williamsburg, and that he should have been allowed, JD should have been allowed to bring in his own safe food. My child, Piri, on Monday was going on a school field trip to Hershey Park. And we had to have a discussion, because you got to bring your lunchbox, so I don't know what you can eat there. I don't want you to get sick at Hershey Park. And my kid, who I thought knew all this stuff, didn't know all this stuff, and he was really nervous. And he's like, well, what do I say? When I go through security, if they see my lunchbox, it's like, what do I say? And it was kind of a strange moment to be breaking down this decision that had just come out for my 12-year-old about, okay, so these are your legal rights, and this is what you say, and this is how you can assert them in a way to hopefully get access. He didn't end up having to do that, but he did say, well, can I just tell him who my mom is? And I'm like, that will get you nowhere. They don't know who I am. Good luck with that. But this work is very personal for me, and it has the potential, I think, to really change the world, as I've seen for my own child, when somebody has the courage to stand up and say, what happened to me was wrong and I deserved better than that, and I'd like to have a seat at the table, or I'd like to be included, or I think I should have a job even though I have this disability, I just need accommodations. Those people who have the courage to do that, they really advance the ball for everybody. So I'm happy to answer questions.
Mary, thank you so much.